Hey y'all, thanks for coming by. This is Alfred Einstein with the Pockets of Specialized Knowledge Studios here in beautiful Orlando, Florida. My website, pofsk.com. Go there and visit. I got all kind of treats for everybody. Today we're talking about Understanding Foreclosure Litigation, Part 2, Clerk's Docket Sheet. Okay, I'm not going to put a link in the description, so if you want to get a copy to follow along, you can go to the case number I list there in Orlando, Florida, or Orange County. There's the case number, there's the plaintiff defendant, there's the recorded document for the LP is. So yeah, you can look it up if you want. If you don't, just sit tight and I'll teach you anyways. Okay, so we're looking for the clerk's docket sheet. The clerk's docket sheet is historical accumulation of all documents, answers, defaults, notices, hearings, and orders. Learning to read the clerk's docket sheet is an invaluable skill for anyone interested in following litigation. So if you can't read a docket sheet, you can't follow litigation. It's as simple as that. And it's not nearly as difficult as it might appear. So I'm going to walk you through it. If you have any questions, I'd love to hear any comments if I screwed up or if I made a good point. I appreciate it very much. Okay, so it all begins with a complaint. Look at that little guy doesn't look like he's happy at all. Well, that's the plaintiff. That's the mortgagee because he hasn't received any payments. He's in the business to make loans. He wants to receive the payments. He wants to receive the money. He's got to pay for the taxes. He's got to pay for the insurance. It's all included in the payment. But if you don't make it, it turns him sour. And this is our plaintiff. And it starts out with the complaint being filed. Now what happens is once the complaint is filed, the clerk has their hands on it. They look in the body of the complaint. And a lot of times you'll be able to see little check marks next to all the defendants so the clerk can be certain that they get summonses out to all the defendants. Now, why are there so many defendants on some foreclosure suits? Some foreclosures, you have the plaintiff and the defendant, and it's only one person. That's because only one person signed the mortgage note, and that's a simple one. When you see a plaintiff with a dozen defendants, it just means that there's a lot of people that may have an interest in that real property, and they're going to have to be foreclosed out, so they're going to have to get a summons delivered to them, giving them 20 days to file an answer. So that's why sometimes there's a lot and sometimes there's a few. Defendants file answers. It's not as easy as a little bubble thing that the girl on the screen is doing. The defendants have to file an answer that essentially will, hopefully for them, protect their interest and not allow the foreclosure to go through. This is rare. This is rare that a defendant can file an answer that makes a mess of the foreclosure. Now, the only answer that I've ever seen that can really make a mess of the foreclosure is when the defendant answers that they paid the defendant or the plaintiff all their money and they attach a copy of the check. That'll screw it up. But other than that, most defendants file answers and it's just a process and it's not going to go anywhere. Defendants are defaulted out of the action. If a defendant gets served, which they have to be served, if they don't answer, they get what's defaulted. So they had called defaulted, I'm sorry. The summons will say they have 20 days to respond from the date of service, not including the day of service. Then they have 20 days to consider whether they want to file an answer. And in light of the fact that most defendants' answers are just going to be mental masturbation, they don't file them. And in that case, the court deals with those people and they just default out defendants. In other words, the defendant is not involved in a lawsuit. They can't win because they didn't file an answer. They can't get anything additional or extra out of the lawsuit because they didn't answer. Now, the one defendant that always answers is going to be condo associations because they got, A, they have attorneys that they have to pay to do this. And B, it's an abundance of caution why HOAs do it. But most defendants aren't going to file answers. They're going to get defaulted out, and that's the last they'll ever hear of anything in that lawsuit. Okay, if a defender files an answer, depending upon whether or not it's an HOA, whether it's not a municipal lien, there's a lot of there's a lot of ways that the plaintiff's attorney will handle this. Most defendants' answers will be handled with a hearing where the attorney for the plaintiff will set down 5 or 6 answers for one hearing in front of the judge. Now, from what I understand, if there's an IRS lien and they file an answer, if there's a municipal lien and they file an answer, or there's an HOA lien and they file an answer, I think there's something within the law where the plaintiff's attorney is required to set those for separate hearings. And I don't know, I'm not certain which one it is, but I know that plaintiff's attorneys setting hearings and talking to judges about answers is the way that the court dismisses these answers. And that's how it's done with most answers. So they'll file the answer, and the plaintiff's attorney will have to set a hearing to dismiss that answer, which is why if you file a foreclosure action and there's only 2 defendants, that means there can only be 2 answers that the attorney has to overcome. If, on the other hand, there's 50 defendants and there's 50 answers the attorney has to overcome, he's going to charge you more money because it's more work for him. Okay, or her, by the way. Okay. So then once the defendant answer has been dealt with the court, they heard the answer and the judge decided it wasn't monumental to the case and there's nothing that they're going to be able to do, they'll just proceed right through it, or they got defaulted. So all the defendants have to be addressed one way or another, and then we either go to trial, summary judgment, or final judgment. Trial is obvious. Summary judgment is that the judge and the plaintiff's attorney, they discuss the case, and if there's no issues of merit that need to be handled by a trial, it'll go to summary judgment, which is a quick way, which is a fast way to get things done. And then after a trial, they'll get a final judgment of foreclosure, and that's going to be the end of the day. Final judgment of foreclosure will contain in it the sale date, the amount of the plaintiff's amount of money that they've been awarded by the court, and several other items that are very important to the foreclosure case. Now, I don't have it on there, but part 3 of understanding foreclosure litigation is going to me. I'm going to go ahead and take apart a final judgment of foreclosure so you can see the moving parts within them. But I think this is the last slide for this one. If you have any questions, please put them in the comments. I'd love to hear from you. If you're not subscribed yet, please subscribe. I'm working my way, however slowly, to 150 subscribers. Let's get that thing going, baby. So in any event, thanks very much. I hope you learned something, and I'll see you again in the next one. And remember, you don't know what you don't know. Thanks again.